Good afternoon, Judge David Morris on behalf of Pleasant Lake Park LLC.
Your name, sir?
Christopher Genovian.
Genoviak. Okay.
The W is a V.
Got it.
It's Polish.
All right.
I apologize the way I exited last encounter. I just a little bit of pain. My first time in court. I wasn't just wanted to get out of the Thunderdome. So, but Mr. Allen, good to see you again, Mr. Allen.
This is the Thunderdome?
I consider
We're gonna
where I'm sweating is the Thunderdome.
Oh, okay. Okay.
Which is about 98% of places I can count.
I was gonna we could put something outside. The Thunderdome. All right. Okay, where are we on this case?
This is our third hearing on this case. Last hearing, the second hearing, court directed plaintiff to engage a critter control business to do an inspection of the premises.
Correct.
And directed that the defendant put November rent into escrow. Because of the timing, I drafted and have a signed unsworn declaration of the inspector that can produce to the court.
Okay. Yes. Have you seen it, sir?
I haven't seen it. I mean, I know.
Okay.
I know what it may say, but
Well, go ahead and look at it.
I'd rather hear your evaluation, but I'll read it. But this is quite a lot. I don't want to waste the court's time.
Well, not,
It's a lot of points.
I'm getting paid, so you're not wasting my time.
I may need to adjourn to call my attorney if that's free, and that's been referred to me for free by the state of Michigan. I may need to refer this. I may need to adjourn. I don't know. This is a lot. But I have prepared my statement.
Well,
which is brief and short.
Well, but hold on a second, sir. So I'm looking at this, and there were certain specific things that you complained about that were happening as a result of an infestation of some type. This is basically indicating that there is not or no evidence of an infestation.
So that's completely contradictory to the reality in which we live in. So I was interested to see I wanted to see what Mr. Weasel's inspector said, and to make this very clear, I think this is the most important part. Mr. Weasel inspector is my next door neighbor. He never provided a valid card. His company is not licensed or insured, and he hasn't proven that. He's my next door neighbor, and I believe there's a conflict of interest. Mr. Weasel owns a trailer park that the inspector lives in. There's a major conflict of interest. This is the burglar investigating himself, essentially. And I'm satisfied with whatever you decide, of course. But there is rat poop in my living room, and Mr. Weasel. And
Okay. Hold on, sir.
Okay. There's a lot of.
So why? I guess part of it. My question is, why didn't you put the money into escrow?
I just forgot. I'm looking for a job because I'm unemployed. I have the money. I can prove to you with bank statements that the money's there. I have over $3,000, almost $4,000 maybe. But the money's secure. It's there. I'll have.
Well, but hang on. It's got to be placed in court escrow.
Okay.
Right.
It's my first rodeo.
But I was kind of clear with you that you had to place that within 7 days of the last hearing, so it should have been in at the beginning of November.
Oh.
By November 7th.
That could be an escrow within by the end of the day. I was really just focusing on employment because I haven't been sleeping because there's a lot of rats and mouse. I spoke to Mr. Weasel this morning, and we both confirmed that we're going to do more inspections and maintenance. And that he confirmed to me that the baseboards in my kitchen are like flappy, and we didn't look for that because there's many holes around the skirting of the trailer. So that has been about almost completed. The skirting around my trailers.
Are you planning on hiring an expert to?
I wasn't prepared for this denial of reality. So now I'm forced to call like Terminex. That's like a licensed and insured inspector, not a license. The gentleman that did this inspection,
I hear you.
okay. The gentleman that did this inspection, like literally lives 2 houses down, and he doesn't own a car. His car used to say critter control on it, but it's gone. When I asked him where his car was, he said it's in the shop. The gentleman is very kind. We were all three at Mr. Weasley.
Oh, okay. All right.
We all witnessed poop in the house, and the poop is still there. There's still poop in my house. There's still holes in my kitchen and multiple places. The evidence is coming out of my ears. But I was not prepared for this denial of reality. I was expecting a deal, so we could all go back to living in peace and harmony. I was not expecting this to go on.
Well, have you called?
I'll call
Counter-
next now.
No, hold on. Have you called? If you were expecting a deal, have you called the attorney's office to see about working something out?
I spoke to Mr. Weasel about making a deal multiple times in person and on the phone, and he just says he doesn't want to talk about it. But that was a few days ago. But when I talked to him this morning and complained about continuous rat poop and that the baseboards are now there is super evidence. There is chewing, and they're chewing on the rug in my second bedroom, and the carpeting. There's like carpeting all over my house.
Sir.
Yes,
I heard you the first time that you were here. I'm hearing you now. I understand that what you are saying is going on. That is why I asked plaintiff to get somebody in there to look at it, to provide something to the court with regard to what basically do an inspection to see if there's anything there.
Yes, Judge, there was an inspection done by Stephen Stamper, and frankly, to the point, to the allegation that there's some conflict of interest, I'm personally not aware of his living where he lives, but this statement submitted under the penalty of perjury by a person who is qualified to do animal control, frankly, our court system would come to a halt if we just said that someone knows someone who did something and they made a sworn statement, that this is a legitimate sworn statement. He will testify to the truth of these matters. He did an inspection of the outside and inside of the premises. There was no signs that and I spoke to him regarding this, he found no signs of ongoing animal activity. The primary purpose for this inspection was to look for something like a beaver or a bob under the premises. That he found one several-month-old animal dropping that he believes to be from a cat. He had done prior trapping events, and really nothing. There is no ongoing animal activity under the premises. He found the condition inside the premises, which he believes to be a product of the tenant's living condition, is conducive to mice and rodent presence. He didn't find any specific evidence of current mice or small rodents, but he wouldn't be surprised if there are mice or small rodents that would be attracted. And it's the landlord's position that attractive nuisance can be mitigated by the defendant, and any further work or trapping needs to be done in conjunction with cleaning the interior of the premises. So frankly, it's a large number of properties have mice and other rodents, and it's not surprising that he may see signs of a mice.
Michigan in the winter and there are mice indoors. What a concept. What?
So point number 17 is clearly perjury. I did not see any signs of ongoing animal activity inside the premises, period. That is completely false. And all three of us were there, and we witnessed poop in my northeast corner, and there's also poop underneath my stove, and we need to reevaluate the baseboards, and that will wash away.
All right, sir.
This delusion here.
Sir, how long is it going to take you to get Terminex out there, or whoever you're going to get out there to give you your own?
So they said they would do on the website. It's like the next day for a free inspection, and then so I guess there's a free inspection the next day. But if there's going to be any kind of action, that's going to cost a whole lot of money. There's rents, and the things are in the vents. The baseboards right now, ground zero is the baseboards. That's all I'm complaining about. But specifically number 17 is, he's liable for perjury in that. And I may pursue him to go to prison for specifically 17.
You have at it. Okay.
Specifically 17.
Okay.
That's my first thing I look at. So,
You have at it.
Can I make one comment, Your Honor? Thank you. That Mr. Stamper took a, what he called an endoscope, which I believe to be a camera attached to a small tube.
Yes.
And went in the heater vent because that was complained of. There was no findings in the heater vent. He
I
went.
never complained about the heater vent.
There was also a purported hole in a cabinet under a heat sink that was inspected. So, this moving target
I hear you, counsel. Because the last time we were here, we weren't really even dealing with, at least I didn't think, small rodents. We were talking about large
I made a point on that.
animals.
I made a point specifically because I knew you were going to comment on that. So so we have done the deduction process. The skirting is complete, almost, I think, complete. Outside my house, there's 2 mouse boxes, and then he also bought me vent covers because there was holes in the vents. That's been completed. So we covered, and then after we got the deduction process, and now I'm like, where is all the chewing,
Okay.
noising?
Okay.
It's the baseboards. The baseboards is ground zero. That's
All right.
normal.
We're all in the baseboards.
Baseboards.
But that's what you're saying.
Baseboards. Sorry. I'm just, sorry, Judge.
So, plaintiff got their inspection. I am looking at that. That does not show any signs of anything that you complained of the first time. You are going to, although it seems it's a different thing now, irrespective of that, you are now going to get your own inspection. So my question is, how long is that going to take you to do? Because at some point, I'm getting this thing. We're going to try this thing.
Right.
I'm not going to listen to it every week without
Yes, Judge. So I'm
render a decision.
Yes.
Go ahead.
Yes, Judge. I'm gonna go on the internet and I'm gonna contact Terminex. I'm gonna do the free inspection like as soon as I get home. And I mean, they may arrive today or tomorrow. I mean, probably tomorrow.
All right, great. If they arrive tomorrow, then I can put this off 1 week.
Yeah.
Got plaintiff's inspection, which doesn't show anything indicating what you were saying before, but now, admittedly, as plaintiff has said, the target has changed, but now you get your inspection, and then we'll see exactly where we are.
The skirting, I'm not satisfied.
Okay.
Yeah, I mean,
And that's,
yeah.
Okay.
I don't want to be here forever, but I mean, my trailer is the closest to the wood line, and there's a lake. This is all.
I know you told me. It's closest to a wood line, there's a lake. That's where I think the big beaver like thing came from before. Yeah, I know. I heard you. People don't think I'm listening. I hear everything. Even though I don't want to sometimes. I hear everything. So I'm going to adjourn this to November 21st, 2025. What time? 3 p.m. And the defendant, you're to do 2 things. I want that escrow paid, and you're to bring your inspection report.
Yes, Judge. Thank you, Judge. Thank you for your time.
All right. Thank you.
Thank you for your service.
You're welcome.
Judge.
Thank you, Counsel. It was much better than last time. It was okay. Okay. Well, for the rest of you, I'm all done. That's it. I can't take any more. Court does kind of submit to the court.
A counterclaim.
Have you?
Judge.
So this is our 4th hearing. Last hearing, plaintiff presented an inspection, an unsworn statement by an inspector, and Mr. Janowiak asked for 1 week to get his own inspection done. I understand that he has done that. He provided me a copy of an inspection report today, just before the hearing. And I understand from the Register of Actions that he filed a motion to set aside default, which maybe is the counterclaim. I'm not sure.
I don't understand how I submitted the money. I don't know if I did that. I don't understand how I submitted money. I don't think I did that correctly.
How you what?
The money that you ordered to put in escrow,
Yes.
it's like a holding, like, you may give me all the money back, hypothetically. I don't think I submitted the money correctly. Because I don't want to I put $12.30 in escrow because there's a $20
You did.
Why are they putting this over here?
I don't know. They also made him fill out this form. I don't know. That's why.
Oh, I see.
I told you about
Yes,
that.
you did.
Yeah, I think I did that.
No, the money, the escrow's there. We had a clerk that, I don't know why they did this. What they did, counsel, is apparently the only way that they ever saw escrow come in without an understanding that I ordered escrow was on a motion to set aside.
I see.
And so they had to fill out that form, which really means nothing because there is no judgment had they looked.
Yeah, I'm ignorant of my actions. I don't know.
No, it truly, sir, there may be other things that are your fault. This one's not. So, well, okay.
The proof.
You can hand it to me when I want you to hand it to me. You really do not have to bow. Okay. Have you seen the counter complaint?
No, I'm not aware of a filed counter complaint. And for the record, I haven't seen a copy of an answer, haven't seen any writings by the defendant.
Okay, so let me just back up a second. What did your report reveal?
It revealed conspiracy and perjury by the landlord, Mr. Weasel. And
Oh my gosh.
investigators.
No. You had an inspection.
Yes. The inspection determined that there is a complete infestation
Of what?
of rats. A complete infestation. There's rodents everywhere. Throughout the home in areas like the rotary room and wide open, and you shouldn't see. This is usually a sign of an infestation. The loose material underneath the dresser and behind the stove is from the rats trying to create a nest. The loose material behind the stove is from the stove's insulation. And be very.
Who's this from?
It could be a fire hazard. This is from a company called Proof that has over 100 years. I have colored photos and I have the licensed insurance.
Okay, just let me,
Would you like a copy?
thank you.
I gave the kind lawyer a copy of this. Sorry. I don't know if that's that you give him what I gave you.
Yes.
Okay, so we have. Right. That is what I have. So the technician comments are there are more pictures I did not.
Okay, were these pictures a part of his report?
Yes, sir. Yes, Judge.
Okay.
I haven't slept a single night since August. I called the police twice because I thought there was people outside my house, but it's really just a rat infestation. I've tried to get resolved and they wouldn't do walkarounds. So since August, I haven't.
Called the police on the rats?
This is the rats. Yes, there was more creatures. The whole house was just, there was holes in the skirting and there's proof. There's holes in it underneath the cabinets are connected to the wall. It's a complete rat hotel. I hear them every night. They chew my property. This is complete opposite of what this client said. His inspector is my next door neighbor. There's a conflict of interest in here. There's conspiracy.
Okay.
Perjury. I might take this to trial to get them on record, so I can later sue them.
Okay.
I might take this
All
to trial
right.
to get them on record.
Okay, all right.
I might. You're judge.
Well, we welcome any trial if you would like to file an answer and a counter complaint. Your Honor, frankly, this is the first that plaintiff is hearing of rats. And this whole case it's on non-payment. For weeks or maybe months, the defendant has been complaining of a beaver or a badger under his premises. My client has been taking steps like trapping, poison, inspection under the premises, outside of the premises. We filed a non-payment complaint, and the defendant still did not raise this issue. First hearing, second hearing.
Oh, trust me, counsel, I remember everything
Thank you, Judge.
on this, and I just. What's in your counterclaim?
My counterclaim, Judge, has a photo evidence of a complete rat infestation, the complete opposite of what.
Okay, but is that the counter complaint?
I mean, this is enough for his client to be convicted of perjury and conspiracy.
I don't know what that means. I'm just asking, is that your counter complaint?
Yes, Judge.
Can I see that? And counsel, I'll let you take a look. I'm trying to. Oh. Lord, we'll see. Here. It's the report.
Yeah, that's mine. Yeah, this just proves everything that he's been saying the whole time. Because this is a licensed and insured rodent pest control with over 100 years of experience. And his rodent and pest control man lives on the same property that Mr. Weasel owns, which is a conflict of interest, and he's not licensed or insured. The inspector doesn't even own his own vehicle. He lives with his kind elderly father, and he used this.
Sir, do you understand that
I don't understand.
is not, it's clear that is not a counter complaint.
Should I put it in writing?
Well, that's usually where it starts.
Okay,
Yeah.
I know there's an order of operations and proper, ways of operating here. I thought this was sufficient for the court, that this is a professional who's licensed and insured with multiple lines contradicting the plaintiff's claims. And I want to make a deal. I want to leave. I feel like I'm being attacked.
You want to go?
My deal is, my proposed deal is not a serious one. I do want to go, but
I don't know what that means.
yeah,
What do you mean?
I would like to hear a deal. I could propose a deal, but I mean, I really want to stay here and get this rats out of my bedroom. It's literally in my bedroom. It's literally I have a stick just to poke the rats underneath the dresser. I literally have a rat stick next to my bed. For the record, I literally have a rat stick next to my bed for 5 months. So I could put this in writing. And I'm sorry to waste court time. I've been trying to make a deal, but I tried to do a walk around and I tried to do a proper investigation months ago, but
Okay, sir,
yes,
there are certain ways that you would have to do an answer and a counter complaint. Okay? And you need paragraph by paragraph laying out your allegations as against the plaintiff, as well as answering the plaintiff's claims in this case. You follow me?
No, I don't understand. I thought I did that when I first did the paperwork for the contract. Like, it says like, how do you respond to the claims? And I was just like, yeah, I disagree with everything but like the money portion. So, I just thought this was like pretty cut and simple. Like, if there's a fly in your steak, you're not going to charge it with potatoes.
But sir, you started out with like a beaver or some large like badger type animal under there. Then when you came back the last time, we weren't talking rats. You were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah.
Now I get here today and now these mice have grown and now they're rats.
Oh yeah, the problem's gotten way worse. I agree with you, Judge. Problem's way worse now.
You're not really saying the mice grew into rats.
I'm saying that the rats have been there the whole time and that we haven't done a proper inspection. We haven't done it proper since the get.
All right,
Sir, Judge.
sir, go ahead.
It's plaintiff's position that to the extent this is a defense about habitability, that this is the tenant's willful and that the tenant has caused these through irresponsible conduct and or lack of conduct. To the extent he has a rat stick or anything else, this is the first plaintiff is hearing of it. This should have
First I've
been.
heard of rat stick.
This is that any, to the extent the landlord should have trapped, should have baited, should have taken any steps, we needed to have been made aware. We were not made aware. It's clear to me that defendant has taken no steps, no meaningful steps to resolve the issue. His living conditions invite the issue, and that we can't be in a position, the landlord cannot be in a position to check in on the defendant to ensure that his quality of life is where maybe it should be. I submit to the court that there is no tribal issue here. To the extent the court disagrees or believes that there should be another chance to file something in writing, I think this needs to go to a trial, a short trial.
I want a bench judgment.
I'm sorry?
I want a bench trial. Judge.
Well, that's all you're entitled to at this point because I don't have a jury fee. So,
Correct.
so,
one other point for the record, Your Honor, is that management understands that, so there have been attempts to go out for the beaver or badger, and there have been attempts to assist with skirting and other various issues raised over the months. Management has been responsive, but understands that there was at some point, defendant in the last month or so made a comment to a neighbor saying that he would shoot management if they came and knocked on his door. He also claims that management has stolen hamburger off of his counter. So we're not sure if these allegations or threats are real, and we have to assume that they are. And this is part of management's concern, is that, frankly, that the situation has broken down, and I think a trial would show that there were no attempts to bring management in on the rat, the mouse, or other issues other than the badger or beaver. And those have been proven or shown through the unsworn statement to be flatly false. Mr. Janowiak's inspector clearly did not see any signs of a badger or beaver either.
hey, so how long is it going to take for you to put your complaints in writing to the court?
I don't understand what I should put,
Well, you're going to need to understand.
because I thought this was, so I'll put, so I know I'm not asking for legal advice.
Good,
But I
I
need to
don't
just-
give it to you.
Right. So, and this is quite the maze. And that's my ignorance. So I can put something in writing within 7 days, once I understand what to put, that's gonna be acceptable to the
All
court.
right, you're going to need to get to figure it out in the next 2 days. Your defendant to file a written answer.
A written answer to what? A written answer
To the complaint.
to the complaint, and the complaint is what, Judge? I don't know. I don't understand what the complaint is.
All right. You got served with a complaint. That's what brought you here. You need to file an answer to that complaint. And if you got a complaint against the landlord, you need to file what's called a counter complaint, or your complaint against him. That you keep trying to hand me is not a complaint. It is not a counter complaint. It is nothing for the court at this point.
I don't understand. So I will submit what so
You're to file a written answer and or counter complaint.
to the
You're to do that by December 3rd. filing of that will only be complete once you file it with the court and you serve counsel with a copy,
I don't understand how to serve counsel with a copy.
usually by email.
I don't have proper access to email all the time. That's why there's like lack.
Okay, get a stamp, put it in an envelope and send it to him.
Gotta get it twice a year, basically. Judge.
No, you gotta, when you file it with the court, you have to serve them a copy because you have to acknowledge that you've given them a copy of what you're filing with the court. Then, so you're to do that by December 3rd. I will give you time to look at that. I'm going to go right to final settlement conference on it. And so I'm going to set a final settlement conference on this case, which is the step before we go to trial. Set that for December 9th, 2025 at 9 a.m. That is in person, and all parties must be present. Now, I'm going to let you know, I want you to understand this, sir. I have a lot of latitude if you don't follow the court's directions. So if you don't file an answer or a counter complaint, but if you don't submit something in writing in its proper form, I'm going to grant them possession. I'm going to grant them a judgment. I'm just going to let you know that.
I will submit a written response. So,
Is there anything else?
no, Judge.
I have great trepidation to ask.
What trepidation?
Never mind.
Could you define that?
Never mind. No.
I don't understand what trepidation.
I'm saying I didn't really want to ask you if there's anything else because I didn't want to hear anything else. All right? Just to be blunt about that. But as a matter of courtesy, I have to make sure that everybody's been heard.
Yes, Judge.
Is there anything else?
No, Judge.
Sweet. Thank you. Everybody have a good holiday. Is this your only copy, counsel?
Yes, it is.
All right. So I'll. Court could stand in recess. I'll be right back. I swear.
All right.
Bye.
You may be seated. Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
Good afternoon, Donna Tope on behalf of Erica and Aaron Ward. They are the tenants in this lease.
All right. Where are we now, folks?
So my understanding is after the long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed it with, I don't think I said that.
well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
I don't know what you have. Keep going.
Okay. So I'm here because I would like to make the statement to the court on the record. This case is a landlord-tenant case. I repeated that in our answer that was filed with this court. The lease is not a commercial lease. As plaintiffs and this mentioned several times, the lease is between an LLC landlord and a married couple, Erica and Aaron Ward. The lease specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. Now, whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiffs to rebut what I'm saying. Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was filed.
I don't know why I need to know all of this.
Because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
so don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tobe.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted to, I was consulting with her as a property manager. I was not her attorney.
Then if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and
And if I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
You were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions, Ms.
Yes,
Tope.
yes,
Whether YouTube or not, it doesn't matter. This is a public record.
yes.
And all I am telling you is that the court saw concern.
Yes, and I am here to address the concern so that it's on the record as well, so that,
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish. You may proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No.
So I am done with this issue.
today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being prejudiced by that. Actions do have consequences, and the consequences of their agent or the actions by tenant's agent have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated, and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action. That's their decision. That should not be with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have the management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So,
Was I their property manager?
So,
Yes.
it's those statements which give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking writing lessons and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or
You can't
contractual
do it that way. Okay. All right.
No, as a friend.
Okay.
I think Ms. Tope's property company should be a party. She has inserted herself into this litigation. And this went from a simple non-payment of rent and has ballooned because of tenants through their council's actions. And it has become a mess.
We filed a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. And you did that. Anything done before that was not in, there was no money put in any trust fund.
Can I just say, so this, let me just ask this. Counsel, are you,
I need to step closer to here. I'm
are
sorry.
you going, we can get the equipment for Counsel, are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments and that these are grounds for defaults and that the lease should be terminated and there should be an eviction order. But if we have to keep going this back and forth way, we may have to. Especially if it's a third party that's handling the rent funds, then we would have to.
No.
So,
Yes.
were you the property manager for them?
No.
Were you involved in the payment of funds to contractors?
Only in the account that Erica used to withhold her funds. And
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was,
There's our problem.
but not my
Okay,
attorney.
so no. That's our problem. So who else was a signatory to that account?
No one else. Me alone. And
Okay, Miss,
the money was filed after we filed the circuit court case.
no, it doesn't matter.
And this court.
Doesn't matter. It doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tope? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. But I don't see a legal problem. So when you say a problem,
Let me ask this,
yes.
since you've given that information. And just think about this for a moment.
Okay.
Whether you believe it to be true or not,
Okay.
plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants had done that before they claimed
Whoa,
that.
whoa, 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 whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards, but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account that,
So if their claim is you can't do it,
well, I
if
guess,
their claim is you can't do it,
yes,
and that the wards could not do it, but then you were the one that did it on their behalf, good, bad, or indifferent, you're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
okay. Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at.
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where Ms. Tope, you're brought in as a party and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not or what position I'm taking. So, Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track for sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenants' agents' conduct by taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks. And my client is going without any rent payments. He got a partial payment, but he is the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.
Okay. Then what were you?
I was their friend, and beginning July 9th, I was their attorney in a circuit court case. And they didn't
I
file.
know what, I know what, I'm not gonna go through what you want, what name you want to place on it. Counsel, you know how the terms agent are defined under Michigan law. So the fact that you are somebody's friend does not mean, for the purposes of agency law, that you may not be acting as their agent.
Well, that one would have to prove I was acting as an agent rather than a friend in order to put the official together as an agent.
Ms. Tope, I don't even know how that comes out of your mouth. If you're saying that they had money and repairs that needed to be done on property that they lease, they own the property that they're leasing, and that you, whatever name you want to place on it, take funds as the only signatory to an account of theirs and do things with it, reference the property, pretty much acting as their agent.
I will prepare withdrawal papers and have them sign it. We've talked about this. They're in agreement after this.
Then what? Why don't we start there? Nothing. All right. So you're going to withdraw as counsel?
Yes.
All right. And then, folks, are you in the position right now that you have counsel, or how? No. How much time would it take you folks to get an attorney? What do you think?
I
Wouldn't know where to start, so I have to look into that.
we typically offer.
Pardon?
You typically suggest.
Well, I don't know. I don't want to bring you back for a hearing and you don't have someone to represent you, but I about to go into December. December, the escrow is going to have to be paid. So while plaintiff's not getting it, it's going to have to be paid to the court. And escrow was deposited with the court. If you don't know that, it did get deposited.
Your Honor, I received a handwritten note. I couldn't read it, but that's good to hear that they did follow.
A handwritten.
I received a handwritten note that I don't know what.
Oh, that was my written request because the court was not available Friday after our hearing. That we went to the clerk to pay the escrow, and we were told that we had to get permission from the court
To pay it in certified funds as opposed to cash. Yes.
They paid it. Okay.
And I filed that with the court, and I gave you a copy so that you knew what I had done in order to try to get the amount paid. And they also advised me that since This case is really in 14A4, but they can't take funds here at 14A1.
Yes, they can.
Well, they say that it's put into a bond and it's very complicated and,
I don't care how complicated it is. They can take the money here.
well, okay,
They don't have to drive out.
I deposited it.
It doesn't matter.
I like the
Whatever.
drive. It was a nice drive.
Okay. So the 4125 is, my point is that is in escrow.
It has been paid.
And that I have the expectation that the 5,500 will be paid within days of December 1st. All right. So I'm going to give the wards time to find counsel. So I'm going to adjourn this to December 19th. Allow them to get counsel and allow counsel to, once obtained, to get up to speed on everything that has transpired. Pardon? All right. So I'll adjourn this matter to December 19th, 2025 at 1 p.m. You said?
Yes.
1 p.m.
Your Honor, my client would like to say a few words.
That's fine. Yes, go ahead.
Thank you.
Thank you.
I don't really want much in regard to the substance of the case, but go ahead, sir.
Thank you. Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that has operated for 22 years without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me to potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied them. They filed a PPO against me. And I haven't even been to my property for close to a year because of how hyper hostile the experiences have been. I won't even take my family there. The PPO was denied immediately. They then sued me in circuit court before my attorney could file for this eviction. This is the 4th hearing over what began as a simple non-payment eviction. They refused to negotiate. Their actions appear intended to harm my family financially. I'm simply trying to protect my property and resolve this properly. Thank you.
Thank you. And to the parties, as soon as the paperwork and the attorneys and the parties are in order, I will expeditiously get this matter to trial, if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 19th, 2025, 1 p.m. Your attorney, once you hire them, will know to file. What they're going to have to do in this case, they're going to have to file a substitution. Well, actually not. I'll need an order of withdrawal sent, and then they can file their appearance. All right.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, folks. Everybody have a great holiday.
Well,
This is got one more. Patrick Becker.